in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.
Hey, folks! Hey, I almost gave up. I thought, she's going to be boring the rest of the day or even the rest of the week and bring out even more bad text messages and boring and boring and boring. But they could not drag it on any longer, and they had to leave it to Mr. Weinstein and Mr. Shard. I told you I would go live as soon as cross-examination started. I fell asleep, so I am roughly an hour behind. But it's cross-examination. I don't mind. Hello, folks. Let's see. To laugh, always have fun. Dark Lotus, Jessica, Colleen, Nora, Denise. Hello, everybody. Let's see. Nick, have you been affected by what news here in the States has described as was a severing of underwater cable between Sweden and Lithuania? We're not affected here. It is an underwater internet cable, one of the really thicker one between Finland and continental Europe, and they have more than one, and we are not affected, and neither is Finland. So, all right. The moment we all been waiting for. Let's get ready to rumble. In one corner, we have Marissa the Burrito. Her strengths are hiding in the bushes, spying on kids, and then make crap up as she goes along. In the other hand, we have the defense of the YSL, Mr. Doug Weinstein and Mr. Max Short. So let's watch the final minutes of the direct examination. Now, I've been listening in once in a while, and I've heard some interesting stuff. Yeah, it's just a very, very weak case. Hold on while I... Well, a few. I don't know if it was damning or not, but something about delete something from the phone, and but every time Marissa the Burrito got a fact question. How did you go about? Well, through my investigation, I found out that. That's not a good answer, in my opinion. Through your investigation. Well, what in your investigation, Ms Burrito? What? But we rarely got any answers. Oh well, it was not. If it was interesting and somewhat damning, or if she was just making things up, I am sure it will be revealed during cross-examination. So let's listen to the final minutes.
GEA conferences I have.
And as a part of your investigation with gangs, have you listened to music associated with various gangs?
Y'all approach.
Oh, what was this?
And
Music. How have you seen, as a gang expert, music promote gangs or promote gang violence in your experience?
Oh, she.
Music is often used to promote gang violence.
sustained.
Have you taken courses on gang music and gang culture?
Yes, I believe during the GEA, one of the GEA conferences I have.
And as a part of your investigation with gangs, have you listened to music associated with various gangs?
Y'all approach.
Oh. The Daubert hearing was already done. The judge already approved of this witness as a gang expert, not as an expert in gang and music and everything. That's a whole other issue. And they already had somebody who talked about it. Oh. Now, there were, I believe, 3 sidebars during this morning and early afternoon and after lunch. So we were at 345. This makes it sidebar counter 346. So the state tried to sneak her in as more of a gang expert. Yeah. Hi, Siobhan. Hi, Sebastian. Hi, Becky. Yeah. Yeah, that might explain why I missed this altogether, because I just happened to fall asleep. Oh, this explains why direct examination abruptly ended. I thought they were going to the end of the day. I really did. I was counting on, I will join and do recap and stuff instead. Yeah.
As you sit here today, do you know if the beef between YSL and YFN is still continuing?
Oh, she lost that hard. She was not allowed to go into music things. Oh. Yeah, they were aiming for going through the end to the end of the day, but she was told, if you're no, we already had the Daubert. You already had her accepted as an expert in this, and this. That did not include gang music violence through music. That was not a part of the Daubert. Or no, it wasn't a part of the Daubert, the original Daubert. back in, I want to say February of 2023, and it was not part of the Thursdays we moved to we moved to have Ms Burrito in as an expert in gangs. So they weren't allowed, and they were probably told, well, if you if this is the area you're going into, that means you have basically nothing left, so wrap it up.
Continuing.
It is.
Course indulgence for a moment.
Oh, Max is at the end of his seat. Oh, they were really told to wrap it up. Oh, and Mr. Weinstein. Yeah. Mr. Weinstein just shakes his head. Oh, they were. Oh, the state. This is the state trying to act as, oh, we were planning on doing. Yep. They were told to wrap it up. Miss Hilton, you loser. All right, let's get into this.
Good afternoon, Investigator Viverito.
Good afternoon, Mr. Weinstein.
How are you doing today?
Good. How are you?
Good. As you know, I represent Mr. Kendrick.
Yes, I do.
All right. Let me ask you a few questions. Excuse me. Permission to approach, Your Honor? I'm going to show you DK16. Do you recognize the individual in that picture?
I do.
I'd like to admit DK16 into evidence. Permission to publish? In Exhibit DK16, who do you see?
Dwayne Carter.
And Dwayne Carter is also known as Little Wayne, right?
He is.
Okay. In the image that is on the right side of the two photographs,
Yes,
you see his arm there, correct?
I do.
Do you see ESPN on his arm?
I do.
And what do you maintain that the ESPN, or do you know what the ESPN on his arm stands for?
On him, since he's not a member of YSL, I couldn't tell you what that stands for.
But he is not a member of YSL, as you correct?
Correct.
And yet he has ESPN on his arm.
Correct. Like I could have a star, Bloods could have a star. Different tattoos mean different things to different people.
So the ESPN on his arm could mean ESPN, the sports network, correct?
As not being a member of YSL, yes.
So if you're a member of YSL and you have ESPN on your arm, are you saying the only thing it could possibly mean is your interpretation of ESPN?
That's what I've seen it mean thus far with members of YSL.
And that's the only thing you believe it could mean?
As far as members of YSL, yes.
So
That's
the fact
serious.
that my client was a football star at Grady Okay.
Consumer effects not in evidence.
Do you know if my client played football at Grady?
I do now.
Do you know if my client got a scholarship to University of Georgia as a football player?
Objection, consumer effects not in
I'm asking if she knows it.
Sustained. You can ask if she knows whether it's true or not.
Do you know if my client got a scholarship to the
I've
University of
heard
Georgia?
that.
You've heard that. Okay. And so would you find it surprising that someone that got a football scholarship to the University of Georgia might like ESPN, the network?
I mean, they could like it, but I don't know if I'm sure he likes other TV channels also that aren't tattooed on him.
So if it's tattooed on you, it must mean ESPN, that you're a member of YSL. You just said that Dwayne Carter has ESPN on his arm,
Objection.
but he's not a member of YSL.
Compound.
Sustained.
You just said that ESPN on Lil Wayne is not a YSL insignia, correct?
Correct. Like I could say, you can see a college sorority girl with a star tattoo on her, right? And then you can go down to the prison and see members of blood gangs with 5-point stars tattooed on them. It's going to have, we look at everything.
Oh, she's really making crap up as she goes along. This is so. Oh, Mr. Weinstein has her in the. I mean, this is the quality of the state's witnesses. He's just a few questions in, and he already. Miss Burrito, you're an idiot, aren't you? Oh. Oh, wow. Oh, wow. Oh, I can't wait for the rest of this. I can't wait for the rest of this.
On an individual basis. So I can't make that determination. When it comes to YSL members, when you see ESPN associated with a YSL member, I have not seen it mean of anything other than every slime play nasty.
And you said you could see a sorority girl with a star on her, correct?
Correct.
And you could see a University of Georgia football player with ESPN on their arm too, correct?
Correct, but they're both not members of a blood gang or YSL.
Okay. Mr. Kokomo.
Miss Burrito, well, they're not members of the YSL. So it can't mean that. Or it can mean that. This is so stupid. This is her making crap up as she has done throughout her career in law enforcement.
Can I get you to come up? May I approach again, Your Honor?
You may.
You got the DK15 video.
Oh, this is amazing. Ms. Burrito have been desperately trying to act as a confident and truthful witness, and within minutes, it's gone. It's gone. No, Dave, it's not a mistrial. Oh, this is so funny.
Mr. Kokomo is going to show you a video. I just want to know if you recognize that video.
Okay.
Oh, yeah, I'm sorry. Would you play a piece of that?
Can I stop for a second? Is that going to show my face on camera?
No, we're not gonna.
Okay, I just
I'm
wanna
not
make-
gonna. I'm not
I
gonna show
just want to make sure.
I'm not gonna show this.
Okay, yes, absolutely.
Do you recognize that video?
I do.
I'm not going to publish this video, but I'd like to introduce DK15 into evidence.
Okay.
Oh, this will be good.
Okay, now I'm going to show you a still from the video.
Sure,
Okay, do you recognize that?
I do.
And do you recognize the individual in that?
That is me. I do.
Okay. I am going to introduce DK15A. And it's redacted. Are you okay with that redaction?
No objection.
Okay.
All right, and that's a still from the video.
Yes, it's
Submitted.
DK15A. It's a still from the video, and it's been redacted to remove the image of Investigator Viverito.
Thank you. It's
Okay.
submitted.
Would you please publish DK15A? Okay. Who is in this still image from DK15?
That is me.
Okay. Do you recall when this was taken?
That was on March 9th of 2020. I'm sorry, May 9th of
Oh, 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 that's the, that's the watch. That's the watch. So between the photos in Mr. Williams' house and through evidence, who handled the watch? Oh, what car? Oh, I wonder what car she drives. If it's $100,000 car, we know where she got the money for it. That's the missing watch, folks. That she is handling right then and there. Oh wow! Oh wow!
2022
And where was it taken?
at 355 Allison Drive, Northeast, Atlanta, Georgia, 30342.
And whose home was that at the time?
The home of Jeffrey Williams.
And where in the home are you?
Should be the master bedroom closet leading to the bathroom.
And in the video that you watched, which I'm not publishing again because it has your image on it,
Correct?
what are you doing at that point in the video?
We're inventorying the jewelry and items.
You're inventorying the jewelry and the items? No, you didn't. It was never inventoried. It was put in one bag, labeled jewelry. Oh, oh wow! Oh wow!
That are in the home.
Okay. And is this image that is taken, that's part of your inventorying procedure in the home? Is that correct?
It's a documentation procedure, yes.
Okay. And do you recognize what you're holding in your hand in this still image?
I do.
And what are you holding in your hand?
A watch of some sort.
Okay. Do you know if do you recognize that as a Richard Mille watch?
I guess, yes.
And that's a pink watch, correct?
It's pink and either pink and light pink or pink and white, yes.
It's a pink band, correct?
Correct?
And it has a white ceramic, I'll call it the body of the watch.
White, yeah, I guess it's white if you say so, yes.
Okay. After you took this image
Mhm.
and you did this inventorying process, where did the watch go after this?
If you watch the video in its entirety, we're inventorying everything in the closet. There's a bunch of small boxes everywhere. So if you watch the video in its entirety, you take it and the watch is photographed like this, box is closed, it's taken and put up on
Box is closed.
the shelf in the upper left-hand corner, and the inventorying continues. And then jewelry starts getting packed up and getting ready for the evidence team to come and take it down to property.
Okay. Since November the 4th of this year, have you spoken to the state about this particular watch, the pink watch with the white band that I've been calling the Richard Mille or Richard Mille watch?
To the state, no, but I've seen like Twitter coverage of it going missing or whatever you want to.
Maybe
Well, no, I mean, there's a camera in here. They know that it's being live streamed. You just are not supposed to be watching it.
Oh.
And
Oh.
you asked that in the evidence.
You no, you're not to partake in any coverage of this. Oh wow, Ms Burrito is checking Twitter. Ms Burrito, Ms Burrito. Hello, I'm Nick. I've been covering this case for almost 2 years. Got it, Ms Burrito? On Twitter. I'm going to post this on Twitter. Fuck you. Oh, I'm going to have so much fun.
well,
Just keep moving.
I wasn't watching the trial, but my name.
Don't
and-
worry about it.
Okay.
Just keep moving.
okay.
Unless you need to approach about something else.
No, that's fine.
Okay.
Okay. So tell me, and I'd like to know about this. Tell me in the whatever coverage you saw, what did you learn about this watch that came up in this trial?
Sustained. Well, yeah, sustained.
Okay. So after this watch was inventoried and you left it for, I'm sorry, who did you say takes the watch after the inventorying process?
So if you watch the video in its entirety,
Which I can't show here, but go
Right.
ahead.
but if you watched it, like I watched it, the watch gets boxed back up and placed up on the shelf, and it gets left there by the team as as an accident. It was left there. The home was then turned over to Mr. Williams Sr.
What? Oh, this. Oh, no. I don't. Oh, no. So it was captured, according to Ms Burrito, it was captured, being left by mistake. Not put in the box, just left there. And then handed over. I could bet good money that at one point the camera moves away, they walk out, yada, yada, yada. Are you out of frame at any point there, Miss Burrito? Are you out of frame at any point?
and Mr. Garfield Lamond to take possession of the home.
And is it the normal process when you're taking jewelry from the home or high valued goods that you leave behind a $500,000 watch on a shelf?
First, I don't know the value of it. Second of all, like I said, there were numerous jewelry boxes. It was, if you watch the video, everybody in there had on body cameras. I was made sure I was on camera at all times. There was cameras throughout the home. So you would be able to see if one of us removed a watch, the box remained in the closet. And like I said, the home was turned over to Mr. Williams Sr. and Mr. Garfield Lamond, who were the two people on scene that took custody of the home for Mr. Williams.
Okay, can we go back to my question?
Sure.
Sure. Is it the normal procedure to leave high valued items behind when you're doing a search and then a seizure pursuant to a warrant?
Objection out of relevance
It wasn't answered, Your Honor.
Overruled.
I don't know if there's necessarily a procedure on what you take or what you don't. Like I said, it got left behind. There were other things, like other items of evidence that I had asked to be taken, such as photographs and artwork that had relevance to this case that were left behind by the evidence.
So you ordered thing. Oh God! Let me get this straight here. Let me get. You ordered things to be taken into evidence, and that order was ignored. Is that what you're saying, Miss Burrito? That the cops on the scene, the investigators, listen to you trying to take that and ignored you? Is yeah, I would imagine they would ignore you. What happened between when the camera moved away from the items out, I don't know, Did you meet up with senior and the other person outside? Yeah, now you can go in. Yeah, that's a solid few minutes where anything could have happened.
Evidence team. It was quite a big operation. There was a hostile crowd gathering at the bottom of the driveway, so we were trying to speed it up to get out of there.
Why would you care? You have dozens of cops on site. Why would you care about people in the end of the driveway? And therefore you procedure, slucidure, medidure, yada yada yada. Yeah. Oh, cat Q. Why were you taking inventory then? And where is that inventory? The person in charge said there wasn't any inventory done. It was just labeled jewelry.
So are you telling me that law enforcement has no procedure with what you do with high value items that are subject to a seizure warrant?
Objection or relevant aspects.
It's asked and answered at this point.
Okay. So the watch you say was left behind. What else wasn't done according to your instructions at the home that day?
I believe there were 2 pieces of artwork that were, one was Mr. Williams in a general uniform with snakes on his arm, and then one was Mr. Williams as like the Jesus at the Last Supper with all the people around him that I thought were relevant that were not taken. And like I said, it started to get pretty hostile out there, so we were trying to speed things up.
You said that there were many people with body cams in the
Correct.
home at the time. How many people approximately at the time of this raid of the home, let's call it that, were wearing body cams?
Almost everybody.
Almost.
And did these body cams capture Mr. Kendrick within the home?
I believe they caught Mr. Kendrick running from the home.
That's not the question I asked.
They caught him outside of the home. I don't know how to better. I'm answering
What,
the question.
it's either a yes, no.
No.
Is there body cam image of Mr. Kendrick within Mr. Williams' home?
The body camera image I saw was him running from the home.
Is there body cam image of
No.
Mr.
Answer
Williams
yes or no, and then you can explain.
in the home?
I haven't reviewed all of the entry team's body camera, but no.
Did you see Mr. Kendrick in Mr. Williams' home?
On that, by the time I arrived at the location, the entry was already made. So I did
you
not. No.
You did not? Okay. Did you, there were approximately a half a dozen firearms found within the home, correct?
Correct.
Have you seen any?
Bree asks, why are we giving burritos a bad name? We are not giving burritos a bad name. I mean, burritos is it's an amazing piece of meat or chicken or veggies. I mean, it's a great dish. In this case, it's a dish that's just meh. Sometimes they are. So it's not generalized through all burritos. It's just this specific burrito on the stand. That it's a bland and a bit.
Images of Mr. Kendrick possessing any of those firearms?
I have not.
Have you seen any images of Mr. Kendrick near those firearms?
I have not.
There were drugs found in the home, correct?
Correct.
Did you see Mr. Kendrick with any of those drugs?
No.
Did you see Mr. Kendrick anywhere near any of those drugs?
No.
As far as you know, was Mr. Kendrick in actual possession of any of those drugs?
No, I wasn't there when they made entry.
Have you spoken to anyone? No, let me take that back. Did you speak to Mr. Kendrick at all at that time?
I did not.
Okay. As far as you know, did Mr. Kendrick have any of those drugs? As far as you know.
As far as I know, no.
And as far as you know, did he have any of those guns?
I just know he was in the home where they were located at some point that day.
Okay. Let's talk about the mob ties video for just a moment.
Yes.
So in that video, at the very end, right, we have Mr. Kendrick saying, excuse my language, saying, knock it off your big homie bitch, correct?
Correct.
Do you recall how many times that line was stated prior to Mr. Kendrick uttering that line at the very end?
Multiple.
And it was stated by 24 Heavy, Ricky Hill, correct?
Correct.
And I believe he states it 3 times, right?
Correct.
So Mr. Kendrick is just repeating a line that someone else has written or someone else has said. He's repeating that at the end, correct?
I'm not sure who the writing credits go to, but he did say it at the end.
He's not freestyling it in that it's never been heard before in the song, correct?
Well, it wasn't part of the song. At that point, the song had ended, and he yelled it.
But it had been said 3 times before in the song, right?
Right.
So you're aware there's post-editing that lines can be put into music after the song is recorded, correct?
Right. But the context of how he was saying it, the way he said it wasn't going along with the song.
Ooh, this is interesting. Tell me about that.
It was after the song had concluded, and he kind of yelled it out with Miss Raven, and I forgot who else was with him.
How do you determine that a song has concluded?
The video, the way it's portrayed in the video, I didn't edit it. The way that it's portrayed in the video has ended, and he utters it at the end after the song is concluded.
So what training have you had in music to know, when a song is ended in a particular video, when there's an utterance after a song is ended?
Are you asking me how I know when a song ends?
Yeah, how do you know this in this video? Like you've had training and expertise that tells you when a particular rap song ends and then something is just blurted out afterwards?
I mean, I've listened to the song independent of the video, and that's not on the track.
But it's in the video, correct?
Right, but when the song concludes, it's not part of the track.
Can we put up, which one of y'all are throwing up exhibits? Can you put up 512 VV?
Yes.
Mr. Atkins, thank you so much. Yeah, it's okay. Thank you. I should have told you that. So, thank you, though. Sorry, just give us a minute to get it up. Oh, okay. Okay. We'll talk about something just a moment while it's going to take a few minutes for this to get pulled
Okay.
up, okay? We'll come back to it, I promise. Again, I'm going to go back to the closet, and I apologize for jumping around.
Sure.
When you're in Mr. Williams, did you call it the jewelry closet?
No, it was a closet where there was a jewelry and other things, money, other things were stored.
Okay. When you're in that closet, do you recall in that video that you mentioned how valuable that watch is when you pull it up?
I don't believe so.
I can play that for you so you can hear that.
You can. I don't. Yeah, if you'd like to.
I'll be careful.
Ms Burrito is really combative. She doesn't like being implicated, and I mean she has probably nothing to do with the disappearance of the watch. Probably, not saying exclusively she has not, but she doesn't like the implication. But, lady, this is a court of law. They are the defense attorneys. You know this. You have testified in other trials.
Are we playing the video or just the audio?
I just want to do the audio, so I'm going to
Okay.
make sure we can get that done.
Well, that ought to not pose a problem.
I want to make sure we can technically do that without having an issue.
On it, okay.
Okay. Sadly, I can't play either the audio or the video. Because I want my stream not yeeted. So I have to be careful.
I mean, he could just play it from his laptop if that's an easier way to do it, as long as the jury can hear it.
Okay, can you turn it up?
Just put a mic next
Mr.
to
Kokomo. Follow Mr. Kokomo on
the
Twitter.
speaker on
We can
your
do it from here.
laptop.
We can do it from here.
Don't remember his handle.
And there's
Just to show. We'll just play it for you so you can
Sure.
see that. I just don't want to risk your image being shown.
I appreciate you, Mr. Weinstein.
This is actual shade because Ms. Burrito, her face has been plastered. Before this trial, she was everywhere on social media. Everywhere. On APD's website, everywhere. But they scrubbed her before her testimony, just so she didn't have to show her face. The defense was smiling.
What was the first watch?
I don't
I
know.
don't know how to pronounce it. First watch,
Yeah.
which was also a Richard Mille watch.
Like you said, I may have made about the first watch that made it to
Maybe about
evidence.
the first watch,
Yeah.
which was also a Richard Mille watch
And
or Mill.
I don't
I
know.
don't know how to pronounce it. So you did make it about the first Richard Mill, just not the
That is in
second Richard Mill.
evidence.
Okay. But they're both Richard Mill watches, correct?
I mean, there were several much more expensive pieces of jewelry that were there.
How do you know that if you didn't know how much it was worth? How do you know that if you never really bothered to check the pricing of the items? It seems like you actually did some evaluation.
Also, and this is not my first case with a lot of expensive jewelry.
That's not a flex in this situation, Ms. Burrito. Oh, I've handled lots of other cases with expensive jewelry. Oh, really? Have you? How interesting that you gave up that information. Yeah, let's listen till. Wouldn't that mean she'd know how to handle it so none goes missing? Yeah, it would. And yet, it went missing.
Did you get it pulled up, Mr. Atkins? Oh, great. Thank you. Okay. Let's go back to 512 VV for just a moment.
Okay.
Look at would you read that line below again about running like Ricky?
Yes.
And what is the import of running like Ricky?
It's from a movie,
And what movie is that from?
Boys in the Hood.
And what's happening to Ricky in Boys in the Hood that's running like Ricky has become a meme?
He's getting gunned down in a drive-by shooting,
And what's he doing when he's getting gunned down?
running.
And he's running down an alley, correct?
Yes.
And he's running at a pretty good clip away from the vehicle that is shooting him with the shotgun, correct?
Correct.
Okay. He's not standing on a sidewalk, right?
I didn't insinuate that.
Sorry.
I didn't insinuate that.
No, I didn't say you did. I'm just
Okay.
asking
Yeah.
you a
No.
question.
He's running.
Okay. And he's running directly away from the shotgun that's coming out of a car to shoot him, correct?
Correct.
Okay. This picture here of I guess it's Duke, it's Martinez Arnold, correct?
Yes.
And Diamante Kendrick. This is from June 23rd, 2020, correct?
Correct.
And that is approximately 5 years and 5 months after the killing of Donovan Thomas.
Yes. This picture was more so of importance to me to show the alliance between the Crips and YSL.
Oh, that's right. That's a hybrid gang, right?
Correct.
Okay. And a hybrid gang is kind of like a nose.
So, oh, they are part of the Bloods. They are part of the Bloods. And here, oh, they're a hybrid gang between YSL and the Crips. Do you have any idea, Ms Burrito, how absolutely idiotic you sound?
Of wax, right? It's something that you can twist and pull so that any type of characteristics that you find can meet the definition of a gang, right?
That's not true.
It isn't true. Why wouldn't that be true?
For example, this hybrid gang with Mr. Arnold, this came about when Mr. Keith Troop died and Mr. Williams gave the eulogy at Mr. Keith Troop's funeral. And if you listen to Mr. Kitchens, he tells the story about how Mr. Williams was put in charge to take care of Mr. Kitchens and guide him. And he's the one that kind of took them under their wing and it was okay. And Mr. Williams was the first one to cross color lines when it came to gangs here in Georgia. And they were first uneasy with that, but Keith Troop explained to them, no, it's okay. This is something we do now. So that's an example. And the Department of Justice defines hybrid gangs as a gang member's participation in multiple gangs, vague rules and code of conduct, gangs or different gangs collaborating together to commit crimes. And there's several other definitions, but it's not just something I made up. The Department of Justice defines it too.
No, I know. And what I'm trying to understand from you is I've seen multiple gang experts come in here and talk about definitions of gangs and definitions of hybrid gangs. And it just appears that if a group of individuals don't fit your definition of a gang, that they automatically get classified as a hybrid gang. I'm asking a question about hybrid gang.
Well,
Can you explain what a hybrid gang is?
yes, it's
Yeah.
I gave you part of it. It's traditionally a neighborhood gang or local gang that tries to take on the identifiers of a traditional gang. Like I'm from New York. The gangs in New York are much more structured. The gangs in LA, Chicago are much more structured. I apologize for New York. The gangs are much more structured here in Georgia. You'll see there are neighborhood cliques that will adopt the identifiers, like YSL, for example, adopted the identifiers of sex, money, murder. They were sex, money, murder based in the beginning, but then Mr. Williams decided to do his own spin on it. Like I said, when he was very close to Keith Troop, when he was deceased, or prior to that, like I said, if you watch, there's history about it where Mr. Kitchens talks about he was sent to go help out Mr. Williams at one point. And at first he was uneasy, like, oh, do we do this? And he said,
Slow down also.
Yeah,
and
just-
sustain
yeah.
to your sake.
and that's,
I'm trying to understand without giving examples. If you can define hybrid gang.
it is a neighborhood gang that takes on pieces of traditional gangs. And like I said, you'll have individuals from different gangs working together. You will have the mixed use of identifiers like we've seen through the presentation of evidence here, like here, this snake and the blue heart for the Crips. Vague rules and code of conduct. Sex, money, murder, bloods have a rank structure. I don't know a rank structure within YSL. So they take pieces of what they like and they put their own spin on it, but are still backed by a traditional gang.
So a traditional gang would have a hierarchy, correct?
Correct.
But you, according to I believe the testimony we've heard, YSL as a gang doesn't have a hierarchy.
They don't have, but the Goodfellows, for example, they have,
I'm asking, let's go back to my question.
right,
What YSL?
right.
I would ask the counsel to be able to explain her answer. I mean, the witness to be able to explain her answer.
Well, the answer wasn't responsive to my question.
Overruled. Go ahead and ask your question.
Okay. YSL does not have a hierarchy as a traditional gang does, correct?
They don't have a set of leadership like roles, no.
Okay, so in that sense, they
They don't have a set of leadership as a, so then how is Mr. Williams the leader?
wouldn't fit into the definition of a traditional gang.
But they're still welcomed by members of the Sex, Money, Murder, Bloods.
Can you just answer my question?
Yes,
Okay. So my question was, they don't fit into the definition of a traditional gang.
correct.
So instead, they get slotted over to this catch-all category of hybrid gang, correct?
I wouldn't call it a catch-all, no.
Okay. I don't have any further questions. Thank you very much.
Thank you, Mr. Weinstein.
All right.
A minute, let me just ask y'all a scheduling issue.
This is amazing. Max, what, dog? You amazing human being. You amazing human being. You amazing human being. Now, Doug didn't have much to ask about because Ms. Burrito didn't actually go into Mr. Weinstein's client, but this was amazing. All right, scheduling issues, and then it's Max shot.
Actually, can you give me just 1 second?
That's a nice looking dress.
Are you ready?
All right, thank you, Honorable. Please, court, Investigative Riverito, good afternoon.
Good afternoon, Mr. Chart.
Good afternoon. Okay. Let me just start off with something that you said on direct. When did you start working on this case with the DA's office?
I'm trying to think. I got to probably fall of 21, maybe.
Fall of 2021. And in fall of 2021, when you started working with this case with the DA's office, you were in the section or in the working group with under ADA Love, correct?
No.
Okay, who were you under?
Kara Convery was the deputy district attorney at that time.
All right, and with the DA's office, eventually, you're not with the DA's office now.
Correct.
Okay, but with the DA's office, you worked on this case, correct?
Correct.
Okay, and you worked under Kara Convery. Who else did you work under?
Well, she wasn't on the case, but for the case, I worked under Don Geary.
Don Geary. Okay. All right. Now, in your testimony over the last few days, you've spoken about the work that you did on this case with the district attorney's office.
Correct.
And you've given us your opinions about certain things that you learned through your work at the district attorney's office, correct?
Some, I don't know. I don't think I've given many opinions.
Okay. As part of your work with the district attorney's office, you reviewed surveillance videos.
Correct.
Okay, you drafted affidavits for search warrants.
Correct.
You collected evidence from Jeffrey Williams' house.
Correct.
You collected social media posts
Correct.
from various people.
Correct.
You reviewed Mr. Stillwell's phones.
Correct.
You've reviewed music, in this case, by various artists.
Correct.
Okay. In fact, today, I guess you reviewed a video to make a determination of what type of gun is in a picture, correct?
Correct.
Let me just. You have the link to my PayPal on the top of the chat, and Bree noticed it and sent $5 via PayPal. Thank you so much, Bree. That is so very nice of you. So very nice of you. Thank you so much. Thank you. Let's get on.
Okay. All those things that you did, and there were other things that you did with the DA's office, correct?
Correct.
All right. And you testified that you were asked by Ms. Hilton, how did you notate your work on this case? And then you said that you talked about your search warrant affidavits, that you make them thorough.
Correct.
Okay, but search warrant affidavits aren't memorandums, are they?
No.
Okay, they're not police reports, are they?
No.
Okay. And your explanation, you don't have reports written for the work that you did in this case as a district attorney, with the district attorney's office, do you?
I have, I think, one or two that were witness memorandums, but other than that, no.
Reports about when you were collecting social media posts?
No.
Got any reports on that?
No.
Okay, about whose addresses you were looking at and whose you weren't? Do you have any reports on that?
What do you mean by addresses?
Instagram addresses or Instagram, which people that you were following on Instagram, which people you were looking at their Instagram, what dates you were looking at their Instagram. Do you have reports about that?
No, but they were compiled and each date that they were looked at were noted on the photo.
Okay, so we're just supposed to look at the stuff that you compile and bring to court, and that's good enough to let us fill in all the work that you did.
Objection, argument.
Just take your word for it?
It's cross, I'm going to permit it.
I mean, I'm here to explain it.
Okay, well, that's fine, but,
Right.
you know, what if we want reports? Do you have
I
reports?
said, the DA, now I work at a different facility. When I worked at the GBI, we had a reporting system. The DA's
Okay.
office doesn't have that. So
Missing reports. Who knew? So whatever she did to bring into court, well, I wrote the date on the photo. When did you write that date on the photo? Do you have evidence memorialized in a report? I did this day, that. Did you file it into the reporting system so we could actually fact check if that you actually did what you said you did? Holy crap. Oh, not part. First of all, thank you, Dave, for a $10 super chat. Logan says hi. Hi, Logan. Hi. And Sebastian Müller, 50 gifted memberships. Wow. Wow. Thank you, sir. Thank you. Thank you. That is so amazingly generous of you. Sebastian Müller, you are today, during this stream, you are on Hold on. I hereby name you Honorary Viking, Sebastian Miller. Honorary Viking. Yeah. And gets us to 50 new members. Thank you so much. Thank you, thank you, thank you. Everybody say thank you to Sebastian Miller. And Dave, Olivia also says hi. Hi, Olivia. Hey. And say hi to your lovely wife from me. Dave, say hi to your lovely wife. Dave is married to a Swedish girl. She's very nice. Get back to trial. Can't you more? Just trust me, bro. Police work. Yeah, that's. How are these people getting paid? How are these people getting paid for this absolute sham of work they present? How a jury are supposed to be fact finders. They are there to determine these facts are good, these facts are bad. How can you, as a prosecutor and her as a long-time law enforcement officer, through the DA's office, gang unit, and now the intelligence unit of the APB, which is an oxymoron in itself. How dare you be so sloppy? How dare you? Wasting taxpayers' money. How dare you? All right, let's get back to trial.
I would, in my affidavits, make them as lengthy. There's some, when you see an affidavit of mine, it's pretty lengthy for a reason.
Okay, well, I didn't ask about your search warrant affidavits.
What?
I'm asking about reports and memorandums right now. Okay, and you seem to be saying, well, there was no record-keeping software with the district attorney's office that you could memorialize the work you did.
Correct?
Okay, they don't have a typewriter, they don't have computers, they don't have Microsoft Word, they don't have a pad of paper, they don't have pens, they don't have pencils. Is that what you're saying?
They do.
Okay. But you just didn't write any reports about any of this work that you've been testifying over the last 3 days that you did.
I don't really know anybody that would write a report saying,
You don't know anybody who would write a report about their police work, their investigative work? Yeah, that makes sense. Nobody in the district attorney's office, nobody in the gang unit writes reports because it makes it much easier to go up on the stand and lie and make shit up as you go along.
on this date, I screenshotted this picture. On this date, I screenshotted this picture. That's not really a report. That's not an event I would write a report for.
Well, what if I want to know exactly what Instagram addresses, what individuals that you looked at on Instagram and which ones you didn't, which ones you checked out what they were posting and which ones you didn't? How would I know if you don't write a report?
Well, if I looked at them, the name would be on the post. And if I didn't, there wouldn't be a picture.
Okay, so again, we're just going with what you say happened years later based on the evidence that you bring into court.
I compiled my findings into a folder and provided it as part of the case file.
Okay. And you didn't write any reports about the work that you were doing in real time, did you?
Regarding, there's a report for Waters Road. And the rest of the investigation, like the investigation into the stabbing of Mr. Bennett, can be found in pretty lengthy affidavits.
So you wrote a report for Waters Road?
I did.
Were you at the DA's office at that time?
I wrote it on a piece of paper. It was a Word document.
So you were able to make a Word
I wrote it on a piece of paper. It was on a Word document.
document about that work, just not the other work that you did, like when you were reviewing my client's phone, like when you were collecting things off of social media, like when you were reviewing surveillance videos. You couldn't write reports for those matters.
Today, with a report management system, I wouldn't write a report for screenshotting social media or reviewing a phone. I traditionally put together a PowerPoint or a visual presentation for trial.
Okay, I didn't ask what you traditionally do. I asked what you did do and didn't do.
But that's what I would do that's what I did back at the DA's office, is what I'm telling you. I would do that today with a report management system as I did without one. Those things are not responding to Waters Road. I wanted to make sure it's better suited to put it in an affidavit because it's memorialized in the clerk's office. Systems can get hacked, hard drives can get lost, things can get deleted, files can get lost.
Oh, isn't that convenient, Ms Burrito? Isn't that fucking convenient? Oh, Jesus Christ.
So I prefer to anything that's noteworthy, make sure it's memorialized somewhere.
Things can get lost. That's your explanation. You can't lose something if you don't make it, can you?
Which is why anything.
Yeah, you can't lose it if you never make it.
Regarding my investigation is probably in an affidavit that I've wrote hundreds of pages.
Probably in an affidavit.
If you would give me a case that you're specifically referring to, I can give you an example.
In your affidavits, I would like you to show me an affidavit for a search warrant where you list all the Instagram addresses and people that you checked out in March 2022 when you were pulling their posts. I
That
want
was
to know
cer-
everyone that you searched.
That was served to you in a discovery folder.
Okay. I have the posts.
Correct. So that's all of them.
All right. I'm not asking for the posts. I'm asking for a list of the people that you searched for.
If you look in the folder, you will see the list of people I searched for.
All right. Okay. All right. Mr. Stillwell, you have known him since 2012, is that correct?
Approximately, yes.
He was about 17 at the time.
If that's what the math dictates, then yes.
Okay. You know him to be from the Thomasville area of Atlanta, correct?
When I would encounter him, he would be more in the Mechanicsville area.
Okay, fair enough. You know him, and you know personal information about him, correct?
Such as,
You know that he was raised by his grandmother, Betty Jackson.
yes,
Okay, and you know Betty Jackson is the mother of his biological father. And
correct,
that's where the Jackson comes from.
correct,
And the Stillwell comes from his mother.
correct,
And you know that his mother has never been a part of his life.
correct.
You know that she was a very bad drug addict.
Objection of relevance, Your Honor?
It's going to explain communications on the phone.
All right, overruled.
And you know that she's now deceased.
I know that she's deceased. I don't know the circumstances.
Okay, you know that and Betty Jackson raised Mr. Stillwell, and you've met Betty Jackson before?
I have.
Okay. And you identified her voice on the jail phones.
Yes,
And also in your review of his phone, the extraction of his phone,
yes,
you saw her number under the name Boss Lady.
correct.
You know, Mr. Jackson has a 9th grade education, correct?
I do not know that.
Okay. Do you know him to be a high school graduate?
I don't know that.
Okay. As far as his occupation, as far as you've known him, you know, let's be real for a second. You've reviewed his phones.
Correct.
Okay. You saw mentions of drugs, weed, pills in his phones.
For sale, yes.
Okay, for sale, right. Okay. There was indications in his phone that in 2022 he was selling drugs.
Correct.
Okay. And also in his phone, you saw substantial evidence of his aspirations to become a musician, correct?
Yes,
Okay. You've seen social media posts with him and Wooney Lee at the studio.
yes,
You've seen social media posts where he hashtagged his upcoming projects.
Yes.
You've seen, you saw on YouTube that short video Slap Talk, correct?
That was on his Instagram profile, but yes.
Okay. Did you note at the time that you captured that Instagram post with the song, how many views it had?
I did not.
Would you dispute that it was 17,000?
I don't know, so I have no way to.
All right. And you also observed in his phone his communications with other individuals that were rapping, correct?
I mean,
You saw communications with Mooney Lee.
with Mooney Lee, yes.
Okay. And you saw different references and conversations about renting studio time
Correct.
in his phone. Even we're talking about in March 2022, on March 8th, for instance, there was a discussion about him going to the studio.
Sure.
March 9th, going into the 10th, discussion with Mooney Lee about going to the studio. The Yo is what they call it, correct?
Correct.
Evening of March 10th, discussion of going to the studio run by Mook Tovin.
Correct.
And you know Mook Tovin to be someone who runs a studio, correct?
Producer of some sort, yes.
And you saw the evidence of, you see file transfers on those dates from Mook Tovin and other people transferring audio files.
Correct.
Okay. And that's consistent with someone making music in the studio and then their work being transferred to them at the end of the night by the studio engineer.
Sure, yes.
Evening of March 11th, discussions with Mooney Lee about going to the studio.
Yes.
March 12th, booking a session at the studio.
Yes.
Afternoon of, or excuse me, the evening of March 14th, your investigation, and I know that, and we're going to talk about 10 o'clock and Windsor Street, but later on in the evening, talking about midnight, your investigation revealed that Mr. Still was in the studio.
Yes.
In fact, he when people were looking for him, he informed his grandmother that he was in the studio.
I don't know if I remember that, but I know he did after the murder of Schmeldrink. They were at the studio. Yes.
Okay. So, and you've observed some of Shannon's music.
I have.
You've observed a lot of music in your profession.
I have.
You observe a lot of music. Let's just
I
put
have.
it that way. You're familiar with drill music, correct?
Yes.
Drill music is something that extends beyond Atlanta.
It does.
It's worldwide, correct?
I know throughout the U.S. I'm not too familiar with it internationally, but yes.
Okay. Common themes of drill music, brutality and violence.
Correct.
Is that fair to say?
Correct.
Okay. Who's the baddest? Who's the toughest? Who's the most powerful?
Correct.
A lot of bragging.
Correct.
Okay. Claims about women, about who gets the most women. Is that a recurring theme?
Yes.
Bragging about the guns people own and carry.
Yes.
Okay. Bragging about how much money people have.
Yes.
Bragging about homicides, whether it's true or not.
Some.
Okay. It's a type of music, and whether you like it or not, and I'm not suggesting you like it, and I'm not suggesting I like it, but it glorifies violence.
I don't know if I would use the term glorifies because there are a number of drill rappers that have been charged with homicide
Okay.
or engage in violent acts. So I don't know if it glorifies. There's two sides. It can glorify it and it can also tell the story. So there's two different sides to it.
Okay. So one side, you know people that are in drill music that have been charged with crimes.
What I'm saying is music of that you're describing often feeds into violence.
Okay. And you don't like that, do you?
I don't
You
I don't
feel
like
it.
anybody getting hurt.
Okay. And that's fine.
Yeah.
You feel it feeds into violence. Okay. And what I'm asking though is when you said it glorifies, you said, I know some people who are in drill music that have been charged with crimes.
Correct.
Okay, and you also know a lot of drill music where people claim they did this and claim they did that.
Correct.
And it's not always factual.
No, but being a drill artist doesn't negate the fact that you engage in violence.
Okay, you may,
It could go either way, but being a
Right.
drill artist doesn't negate that fact.
that's fine. Okay. Common terms in drill music, ops,
Correct.
stands for opposition.
Correct.
And that is a recurring theme that you almost hear in every song. Isn't that fair to say?
In every song and almost every investigation that I work, yes.
Okay. And if we, and we're not going to do it, but if we Google and get on YouTube and type in rap ops, we'll see dozens of songs with ops in the title,
Correct.
including by well-known artists.
Correct.
All right. Glizzies. Glizzy is a term that comes up a lot in drill music, correct?
Correct.
So gun.
Yes, but I don't know if I've heard that used that much by these folks that we investigated with this.
I'm just
Yeah,
talking about.
it does. Guns do come up, yes.
Yeah, I mean, it's in one of Shannon's songs,
Okay.
Lizard Walk.
Okay.
Okay, and that's another term that comes up a lot in drill music.
Glizzy, blick, fi, whatever you want to call it.
Red light is another one, comes up a lot in drill music, correct? Red lights.
I don't hear that as often, no.
Okay, you ever hear of the song Red Light by Future?
I have not.
You heard the lyrics, yeah, and this shit real out here running through the red light, looking through your rear view and might just sneak up on the car and try to spray you. You hear that? Heard that lyric?
No, but if Mr. Wilburn would have engaged in a homicide at a red light, I probably would have looked into it.
Okay, I didn't ask anything
Well,
about a homicide or Mr. Wilburn. I asked if you heard the lyric.
But yes, if
Okay,
I would
well,
have been
I'm
something I would
just-
look at.
Okay. Chalk. Chalk you out, chalk them up. Slime and chalk. Those are
Slime and chalk, I'm familiar with, yes.
all right. Those are things that you would hear in drill music, correct?
Slime and chalk, I've heard. The others, I don't know if I've heard.
All right. We heard 5 songs by Mr. Stillwell.
Yes.
Okay. And they were let's see, Slat Talk, Ran This Money, Bullshit, Lizard Walk, and Red Light.
Yes,
And all those songs, you have identified Mr. Stillwell, and they were in Mr. Stillwell's phone.
correct.
Okay, and just to be clear, there were other songs in Mr. Stillwell's phone as well.
Correct.
Okay, so we heard 5 of all the songs that Mr. Stillwell had in his phone.
Correct.
And do you know, outside of his phone, how many other songs Mr. Stillwell has made?
I know through the years I've seen him make a few, but I couldn't give you a number.
Okay. Now, with those songs, do you know when they were written?
No, and on direct, I said I can only see the date that they were added to the device.
Right, and you don't, and let's just be clear, the date that they were added to the device was 3/17. There was some sort of file transfer according to the report
Correct.
on 3/17. You don't believe that on the morning of 3/17, he was in the studio making all those songs?
Not to say that 1 or 2 of them couldn't have been made in the days prior, but I can't give you exact dates on them.
Okay. So we don't know when they were when they were made. Do we know when they were written?
No,
Do we know who wrote the lyrics?
we don't.
Okay, and in fact, on one of the songs, Red Light, it says featuring Vito, correct?
Correct.
Veedo.
Correct.
You know Vito to be a songwriter, not an artist, a songwriter for 300 Entertainment, correct?
He could be, yes.
Um, okay. Some of these songs that we heard have the typical ops, red light, glizzy, homicide, typical things that are hallmarks of drill music, correct?
Correct.
Okay. Now, also, in one of the songs, Mr. Stillwell makes reference to his bankroll, right?
Correct.
Okay. Bankroll is the amount of money you have,
Correct.
the wad of cash.
Correct.
All right. And he's bragging about his bankroll.
Correct.
Okay. And that's what he's saying. That's what he's releasing to the public through this song.
Correct.
Okay. Mr. Stillwell, do you know him to own a car?
No.
Do you know him to own a house?
No.
Do you know him to be independently wealthy?
I mean, sometimes, yes. He has a lot of money on him.
Okay. His bankroll, is that something that artists often talk about, their bankroll and how big it is?
Sometimes, yes.
Is that always true, that the artists that are bragging about their bankroll is really as big as they're claiming it is in their songs?
That's an individual basis.
Okay. Could it be, you ever heard the term, like my son says it all the time, cap? Like just made up, cap.
It could be, but that's not necessarily the case with Mr. Stillwell Jackson.
I'm asking if you've ever heard the
Yes,
term.
I have.
Okay. And artists cap on songs all the time, don't they?
Some do, some
Okay.
don't.
And Mr. Stillwell, in his songs, was claiming that he had a bankroll.
And he did sometimes. Yes, he did sometimes.
Well, on the phones, you reviewed his phones.
Correct.
You saw him basically begging Miss Alexander to give him $1,500.
But if you listen to the March 16th wiretap call, he talks about all the money he had,
Okay.
and he didn't want to go to jail with all that money. So he had a lot of. It fluctuates from day to day. So I don't know. Some days he has a bankroll, some days he has no roll. So
Okay. Did he have a bankroll? Do you know if he had a bankroll the day he recorded that song?
do not.
Okay. Could that have been Cap?
Could have been. He could have been reminiscing about when he had his bankroll.
Okay. In these songs, while we're talking about Cap, let's see. Mr. Stillwell referred to himself as Big Slime.
Yes.
Okay, you ever hear anyone else refer to Mr. Stillwell as Big Slime?
I'm trying to think. He's been referred to as Big Slime and Life Size Lizard.
Right, that's what he calls himself.
He's also referred to as that. I've heard him.
Okay. So he was claiming to be Big Slime in the
Correct.
song that he wrote or performed. Okay. Then we got, let's see, Dolly White in one of the songs. Bullshit, right?
Dolly, yes.
She brags about making $201K in a day.
Okay.
Okay. Do you know, is there ever any evidence that you have that on that day that Dolly White was claiming that she made $201K that day, that she actually made $201,000 that day?
A, I wouldn't know what day it is to be able to tell you. She could have been on Instagram or somewhere bragging about having 200K. So without knowing the day, I couldn't tell you.
Okay. Do you have any evidence that Dolly White, I'm not talking about Jeffrey Williams, I'm talking about Dolly White, has ever made $201,000 in a day in her life?
I couldn't tell you what Miss Greer makes.
Could that have been Cap?
It could, but it also could not have been.
So, we talked about the lyrics on Direct. In these songs, Mr. Stillwell never mentioned an infinity,
No,
never mentioned Diamante Kendrick,
no,
never mentioned Demise McMullen or Nard,
no,
never mentioned Justin Cobb or Doo-Wop.
no.
He mentioned being arrested for a homicide and beating it.
I don't want. I'm going to tread lightly on it. I don't know. Can I get some direction on? how to
He said
pro-
I made
Okay,
a
but I just
murder
want to
rap.
make sure I'm approaching it correctly. I don't want to.
Yeah, I'll ask a very targeted question.
Okay.
He mentioned on Slat Talk, I beat a murder rap.
Yes, he did.
Paid my lawyer $30 for that.
He did mention that.
Okay. He also mentioned beating a homicide on another song, correct?
Correct.
Okay. Do you have, the fact is that Mr. Stillwell, he's on trial for that here today. At the time he wrote those lyrics, he had never beaten a homicide.
That's a real slippery slope to explain that. I don't want to say some. If I can get some.
He had never been cleared or went to trial and was found not guilty of a homicide.
Yes. It's
Yes.
That is a lie, Ms. Vivorito. At the time when he wrote those lyrics, he had not been on trial, cleared, or convicted of a homicide. Because, Jesus Christ, Ms. Vivorito, this is not even a slippery slope. But here she goes, says, well, yes. No, first of all, it's a lie. At the time of when he wrote those lyrics, that's a really easy question. And she says, yes. And she is such an absolute moron. She is so full of herself. She knows what happened later. That wasn't the fucking question, Miss Vivorito, was it? So you can't say what you just. Oh. And it was a very carefully constructed question. At the time when he wrote that specific lyric, that's not a hard question to understand, but Miss Vivorito is a moron. Absolute moron. Well, later on, no, he didn't ask about what happened later. He asked you at the time of when he wrote those lyrics. How does these people breathe without a functioning brain? Let alone getting paid as a part. Folks, the Atlanta Police Department in January of 2023 hired her as a part of their intelligence unit. You can't make this shit up. Yeah, Ms Burrito, you need to listen to the damn question.
So Mr. Shart asked you a very specific question and you seem to have answered in a way that surprises everybody. So we need to get some clarity from you. Okay, so can you listen really carefully to what his question is and answer that question? And then if your answer is still the same, we need to ask some follow-up of you. I mean, okay, go ahead.
In the songs that we reviewed, Mr. Stillwell claimed to have beat a homicide, correct? Or beat a
Correct.
murder rap, beat a homicide.
Correct.
Okay. Did he in fact beat a murder rap or beat a homicide, as he claimed?
I think he,
Go ahead and explain it now because the jury's not in here.
Yes,
We're just
here.
trying to sort out what
I
it
think
is.
from my understanding of Mr. Stillwell back in that time, he was under the impression that the Donovan Thomas case had been, that they were going to beat it. Like they were about to beat it or it was beat or it wasn't going to be an issue. I didn't want to say that because I didn't
Well,
know.
that's good that you didn't say
Yes.
that, but that's not the question that he asked
I'm
at
not
the
asking what
time.
Mr. Stillwell thought. I'm
Okay,
asking-
yeah, then no.
So listen
Okay.
very carefully to what he actually, I mean, that's not what he asked a minute ago, but you don't have like knowledge that nobody else has that he was tried for some
Oh,
other
no, no, no.
murder and got a hung jury or an acquittal,
No,
right?
Your Honor. I just wanted to
Okay.
make sure.
So if Mr. Short asks you, has he ever beaten one, and by beaten, I mean, gotten an acquittal or however he phrases it, what would your answer be then?
No, I just didn't know
Okay.
the specific outcome of if it was.
Has he
Dismissed
even
and
been
reinvent-
tried for
No,
another murder?
he
Okay,
has not
so
been
don't
tried.
say, I don't know the specific outcome if he has never been tried for one other than the one he's on trial for right now. Okay?
Yeah,
You understand?
Oh, now your critical is pissed. She knows this is a really, really easy question to answer to. Now you made the judgment. What is rule number 1 of trials? Don't piss off the judge. Rule number 1. Now you can break in on occasion if it's absolutely necessary. But this broad, this thing on the stand, this is stupidity on a whole different level, folks. How can you not understand? At that time when he wrote the lyric, had he actually beaten a murder charge, a murder trial? No. It's a really easy question to answer.
Understand?
I just thought, I didn't know if he meant it was dropped. That was all, Your Honor.
That's not what was asked.
But that's not what he just asked right here, Your Honor. And
I
think
know
that's-
that. I know that.
I think that's the clarity that needs to be had because at the
Miss
time,
Hilton,
Mr. Stillwell was on bond for the murder. And so
That is not anywhere near what he asked. He asked, has he ever been tried for and acquitted of murder?
but what he
Being given a bond before a trial ever occurs does not a yes answer for has he ever been tried and acquitted.
right, but even the question he just asked right now was not that direct.
I know,
question.
that's
So
because-
that's the-
I know, but just now what he asked, we're just trying to figure out what it is she might mean. And are you then going to ask?
I'll ask about the bond next.
Okay. So if he asked about bond, then you can answer
I-
whatever you know about whether he was released on bond.
I want to be
Okay?
respectful of his rights, Your Honor. That's all.
Okay. Is anybody need any
No,
more
you weren't.
clarity on?
I definitely do, because I think on redirect, I think
Okay.
it becomes very relevant to ask the witness, at the time he wrote those songs, is it, based on everything that you know and speaking to him and other people, that did he believe he beat the murder?
I would not let you ask that because how on earth can she know what is in his head? I mean, you could ask it, but I would overrule it if objection were made.
I'll sustain it.
I understand, Your
Then
Honor.
you point that, if that is in evidence, then you point that out in closing argument.
think we will put them in now. Okay.
Well, y'all have to make a decision, each of you, as to how you're going to present your case, or. All right. Do we have clarity now?
I think I'm clear. Yes, I'm clear.
You're going to answer first a
It
direct
was-
question about.
It was clear all along.
You're going to ask that direct question first, and then you're going to ask about the bond. Okay.
And then, I mean, Mr. Abadi, you suggested that you might then introduce evidence that he said what were you saying?
Well, I think I have to find the call, but I think that creates the questions on redirect that then can be asked is, at the time that he wrote those songs, had he been on bond for a number of years? He makes all of that very relevant as it relates to like diving into why he said that in the lyrics of the song. But I think the whole point of this is a very slippery slope, because we begin to talk about things that I don't necessarily we all want to get into as it relates to objections and objections for mistrial, because all of these questions allow us to then ask on redirect the specifics as it relates to when he made the song and being released on bond, things of that nature that you can argue as to the belief as to why he believed he beat the murder, because it had been 3, 4, however many years. So he had not.
Well,
been
you can
indicted.
ask the had he been on bond 3, 4, however many years. What you cannot ask this witness is, so then do you think he believed he beat it? I mean, that is something
Well, I agree
that
with
this
that.
witness can't testify to, that I know of. If you have some reason to believe you think she can testify to that. But I mean, if it's just, oh, I can put 2 and 2 together, he'd been out for 17 years on bond and not been, tried yet, then that's something that is not beyond the ken of any juror. And you can argue that in your closing, but you can't ask this witness that question, okay?
Yes.
Everybody clear now?
Yes.
Okay. All right, we'll get the jury back. How long is there going to be like a natural stopping point? I mean, I don't mind keeping them till 6.
There'll be a natural stopping point,
Okay.
and I'll be.
If we do that, we have 5 minutes
Right now?
recess, just 5 minutes. All right.
Yes. Yes, we can, because I don't want to break yet again if we're going to go for another hour or so. There you go.
All right, and through the magic of recapping, it was not that long of a break. And now he has to ask the question. I don't know if he asks the questions again. Now, had he, at the time he wrote the lyrics, had he actually beat a murder charge? Had he been gone through trial? And the answer is no.
Thank you. Go ahead, Mr. Sharp.
Thank you, Your Honor. Okay, investigate Viverito. I'm going to go back to where we were before. In those songs, in Slat Talk,
Correct?
Mr. Stilwell says, I just beat a murder rap, paid my lawyer $30 for that.
Correct?
Okay, and in other songs, he says, I beat a homicide.
Mhm.
Okay. My first question. To your knowledge, in this case, I'm talking about Donovan Thomas.
Correct?
had Mr. Stillwell ever been acquitted or the case been dismissed?
No,
Okay. The case was still open, correct?
yes,
Okay. So he had not, in fact, beat a homicide.
correct,
He had not, in fact, beat a murder rap.
correct,
Yet he claimed that on his songs.
correct.
Also, he claimed to pay his lawyer 30 for that. Do you know if he actually paid a lawyer anything?
I don't believe he's the one that paid the lawyer, but a lawyer was paid
Do you know a lawyer's been paid?
at some
What
point.
lawyer?
He was represented at some point.
What lawyer?
I don't know which lawyer he was. I said at
Well, you
some
just
point.
said you know the lawyer's been paid, and now I'm asking you what lawyer?
Okay, a lawyer back then would have been paid for him. I don't know.
What's the lawyer's name? Since you had an opinion on it,
You-
that lawyer had been paid, what is that lawyer's name?
All I said was, Mr. Shart, if he had a lawyer, they would have had to have been.
No,
paid
that's not
somehow. I
what you
don't know
said.
How or who?
Okay, so you don't know how much anyone.
I did
has
not
been
work on
paid.
the Donovan Thomas case at all.
Okay, but you just gave an opinion. And so you don't know how much, who, or how much anyone had been paid.
I just said I don't know who his lawyer was or how much or how they were paid.
The reality is Mr. Stillwell was released on bond.
Yes,
He didn't beat a murder rap. He had been released on bond.
yes,
Okay, so claim I beat a murder rap, that was cap.
if you want to call it cap. I would say incorrect, but sure.
Claim that he paid a lawyer 30 for that, we don't know. We don't even know who the lawyer is,
Correct?
okay? He also said in Lizard Walk,
Yeah. In the midst of everything, she didn't actually work the Donovan Thomas case. And still, she's there as both a fact witness and a expert witness. So she gives opinion about the Donovan Thomas murder. But as you can clearly see, she has no fucking clue what went on in the Donovan Thomas case. None. Zero. And still, she was allowed to put out her opinion on it. Oh, this stream is going to get demonetized.
bond was $500,000 N-word. Remember that?
Yes.
Okay. Do you know Mr. Stillwell's bond in the case that he paid for Donovan Thomas? Do you know it to have been $500,000?
Believe it was almost not $500,000, but it was a very high amount.
Okay, was it $500,000?
I think if I remember correctly, it was 300,000.
Was it $500,000?
That's not close. Oh, Jesus Christ. She said he's trying to assert some information. That's simply not true. 300,000 is 200,000 away from 500,000. That's not even close. Oh,
It was not.
Okay, so that was incorrect. That was cap as well, correct?
Sure.
Okay. Mr. Stillwell, since October 2015, has been charged with the Donovan Thomas murder, correct?
I'm not sure the exact date he was charged, but
Late 2015?
sure.
Okay.
Yvette asks, why is she being so combative? Just tell the truth, B. She can't tell the truth because she has no idea what the truth is. She's making shit up as she goes along. That's why she's so combative, because she's being challenged by Mr. Shard about her opinions, about a case she never worked. And now, this is the thing about liars, as I believe Ms. Burrito is. When caught, they get combative.
And in these songs, he openly talks about being charged for that murder, correct?
Yes,
Okay. And he talks about the money he paid lawyers.
sure.
He talks about the money, the extravagant amounts of money that he paid for bond, $500,000.
Sure.
Okay. I'm not saying you like it. I'm not saying I'm like it. Do you deny that potentially an artist, an aspiring artist, being charged in a high profile case, beating a high profile case, paying large amounts of bond would be something that would be appealing in the world of drill music? Do you deny that?
No, engaging in violence and homicide skyrockets you to the top of the corporate ladder in drill music.
Okay. And he was saying he had been charged and
Correct.
beaten.
Correct.
Okay.
He's been charged for this crime for 9 years, folks. And not until this scam RICO, they actually try to prove it. And we seen the video. We saw a bad Santa cowboy cop ignoring that there was a third car driving up to, and the Donovan Tom, Jesus Christ. Well, the drinks was later on, but the Donovan Thomas, he was probably never there. Probably wasn't even close.
Mr. Atkins, could you, or Mr. Abate, or Miss Hill, could you do me a favor? Or Miss Knightsback, 436 VVA, please, if you could display that for me. Okay, this is my client, correct?
Correct.
And again, this is him while he's trying to be an aspiring artist, correct? This time period?
I guess.
Okay. And first of all, let me just clarify one thing. In the background, we see a gas station. That is the gas station on Cleveland Avenue, correct?
I believe that's 221 Cleveland.
Okay. That's not McDaniel Street.
No.
Okay. Now, Mr. Stillwell in this post also makes reference to Donovan Thomas, doesn't he?
He does.
Okay. He makes reference in the hashtag Peanut Stone Grave.
Correct.
Okay. Publicly, he is tethering himself to that incident.
Correct.
Okay. And in the message he writes, in the caption, it says, I fell off 100 times, 100 times I bounced back. Okay.
Correct.
Let's talk about some things that happened prior to this post about falling down 100 times. Mr. Stillwell, prior to this post, had someone drive by the green store and shoot at his head, did he not?
Correct.
Okay. Mr. Stillwell, prior to this post, was driving in a car with a young lady named Tiara Jones and another lady named Ms. Duncan, and a car sped up behind that car and started shooting at them, correct?
Correct.
And killed Tiara Jones and put Mr. Stillwell in the hospital.
Correct.
Mr. Stillwell, after he spoke to the investigators about the Tiara Jones case, was attacked on social media for talking to the police.
Correct?
All those things happened before he made this post about falling off 100 times and bouncing back.
A lot of things happen, yes.
Okay. Does this post ever say, I killed Donovan Thomas?
Nobody's attaching himself to the incident.
You're absolutely right. He's attaching himself to the fact that the police arrested him and people have been attacking him ever since. Isn't that true? I've been knocked down. I fell off 100 times, and 100 times I bounced back.
Objective speculation.
What?
Sustained.
Okay, I'd like to talk to you about some of the work you did in collecting the posts from social media. And again, I don't mean to harp on this. Maybe I'm not asking correctly. I understand that you have given how many total social media posts did you pull within a folder?
I don't know. They were all compiled into a folder of relevant posts.
Okay, you say relevant posts.
Correct.
So who determined if they were relevant?
If they had anything to do with the hyper violent back and forth, I felt that they were relevant to the investigation.
Okay, again, I'm going to ask, who determined if they were relevant? Who?
It's just that if I felt like they were
So
anything,
you
I would,
determined.
from
you
my, as being the person that's listening and monitoring the wiretap and knowing the ins and outs of what's going on, I was able to determine what was relevant.
You determined what was relevant.
Correct.
Okay. And I understand that we have a thing of posts. What I want to know, when you're on Instagram, do you have notifications set for when people post? Are you scrolling Instagram? Are you looking at certain people's pages and not other people's pages? How are you doing it?
We were monitoring both sides of the conflict, and it's not just me. There are several people that would
She
monitor.
tried.
We'd all look together.
She's not answering the damn question again. He asked, how do you do it? Oh, there was a lot of other people doing it.
Talking
Collectively.
about the social media posts.
Correct. We were monitoring both sides. Part of my job is to mitigate violence. So as a conflict is occurring, we're monitoring both sides of the conflict. So when we see, it's a constant job of monitoring, to where if I see YFN down on Cleveland Avenue, which a bunch of assault rifles, probably not great. So we need to monitor constantly to say, okay, we need to get marked units down to Cleveland to mitigate that. So we're constantly, I have a unit that I work with. Everybody was involved in the wiretap, the investigation. So everybody was tuned into what was going on.
Who's in that unit?
I mean, the gang unit, there's a bunch of people. I couldn't tell you give you a roster at that time. It's changed, but
Okay, well, if we had reports, could we know who was on that unit?
they wouldn't. I don't know anybody in our gang unit that would give you a report of every social media post they screenshot.
Okay, well, I didn't ask if anyone in the gang unit would. I asked if you did. Did you write a report about exactly which users you were following to pick up specific posts?
Mr. Shart, you've asked me that before, and I've told you I've compiled every user you see in the folder is who I was monitoring.
Okay, and what about is there no one else that you were monitoring that's not in the folder?
That folder pretty much covers a whole lot of people.
Okay, and we just take it from you. No reports.
Whether you have all the posts, that I captured. They're in a folder, gathered collectively, organized in a folder for you. So I don't know what, do you want a list of screen names that were
Just
captured?
want documentation of the work you did.
It's documented in a folder that was served in discovery.
Hmm. some of those posts that you deemed relevant are actually lyrics to songs, correct?
I have to see what you're referring to.
Could you, Ms. Knight, could you display 471 VV? 471? Okay, this is Mr. Nichols, Comarvius Nichols, right?
Correct.
Okay, and 471 VV is exactly how the state has put this into evidence.
Correct.
All right, and we're going to get back to exactly what this is in a little bit.
Correct.
But those words, what you saying, I run with cold-blooded killers, okay? When are you saying that you collected this?
Probably 2 days or a day or two after the murder of Mr. Drinks.
Okay?
Probably.
And those words, those are written by Mr. Nichols?
No, it's a song by NBA Youngboy that he chose those words to put on the post 2 days after Mr. Drinks was killed.
He chose those words?
So what this is it's an Instagram story, and you can select a song and which portion of that song. You can select anywhere from 10 seconds to 30 seconds, and you select that, and you can overlay it onto your story. That's what was done here.
Those words?
Mr. Nichols made the social media post, and in the post, he picked this song to accompany his
All
post.
right, you know what? We're not going to get back to this. Let's deal with this right now. Mr. Kokomo, if you would. What is it, 60? Yes, 60.
Again, an easy question. Did Mr. Nichols say those words? No, he did not. It was
Yes.
the answer is no, you did. He did not, but he posted it with this blah blah blah.
This is what. All right. You need to show investigator Gabriel. Okay.
What is he up to?
We can.
I mean,
Do you?
yeah, so that is a screen. Oh, can I explain?
Yeah.
Okay, Mr. Kokomo, I think the witnesses had sufficient time to view it. So thank you, Mr. Kokomo. Do you recognize what's been marked as 60 VV?
Yes, it's a video of his story in its entirety.
Okay, and is that the way you saw it on social media?
It was both a video that was submitted in discovery and a photo that was submitted. The relevant portion of that would have been relevant to our investigation.
Oh, what? Oh, the cherry picking. Oh, the cherry picking. We looked through the entire Instagram story, and then we picked out this part to show to the jury. Oh,
Was that you're posting a video the day after somebody's murdered in your presence.
We haven't even gotten here yet. Do you recognize
Yes.
that video? Okay. Your Honor, I would move to admit DS 60 into evidence.
Admit it.
Permission to publish.
You may.
okay. I can't show or play the song. I can't. I would get this stream would get yeeted. But what Mr. Shard here is doing here is playing the entirety in context. Oh, what happened?
Your Honor, maybe your post before it's published.
Yes.
Oh, look at the smile. Oh, look at the smile. Oh, I have no idea what that song is, but whatever it is really bad for the prosecution. Oh, wow. Oh, the prosecution was really quick. Oh, can we approach before we play this? Oh. And sidebar counter 347. Oh, wow. Yeah, Mr. Shaw knew there was going to be an objection. Oh, the smile. This is why I want to get a hold of the a transcript of the sidebars. I want to listen to the absolute horse shit Miss Hilton is trying to pull here. Skipping ahead. Oh, it's a long one. Oh, it's a really long one.
With y'all for the day.
Oh, oh, it's such a interesting one that she's sending the jury home. Oh, this is bad for the prosecution if they actually want to litigate this.
Right. We're gonna, given the time, and we need to sort out something anyway, we're gonna break with y'all for the day. And so we'll see y'all again.
This is interesting. Remember, folks, in the context here, Mr. Shard has just explained to the jury that, folks, they didn't tell the entire story. I want to tell you the entire story. They only showed you the screenshot that looks bad. Now, Ms. Burrito has said we only took the relevant part to show to the jury. And now this is admitted into evidence. And now he wants to show it. And boom! Miss Hilton, can we approach before? And then they are sent home. The imagery for the jury is, oh, why doesn't the prosecution want to play the entire Instagram story?
Again tomorrow at no, we have a late start, 10:30 with y'all. Is that right? Whatever I told y'all before is what I mean. I can't remember what it was, but whatever I told you. Everybody just be here then.
Okay,
10:30.
jury 10:30. Oh, that's great for
Hang
me.
on.
Then I get. Oh, I can actually live stream tomorrow.
Let's see.
I can actually live stream tomorrow if they have a late start. That's excellent.
Today is, it's 10 is what we have. What's what I have on my calendar. So 10. Was when we discussed this, the outcome of was when we discussed this particular video before. And we're quickly getting to, I think, needing to do charge conference. And I appreciate y'all's work on this late last week and over the weekend. And I think that there's, oh, you can go. We'll see you at 10 in the morning. Thank you. A lot of it there appears to be agreement on. I think the challenging part, if there is one, is going to be figuring out exactly what needs to be charged with regard to RICO. But I'm wondering, certainly in the morning before we have the jury, but maybe for a little while tonight, if we wanted to go ahead and start getting through some of that, maybe can y'all, unless there's any reason, I'd love to maybe take 45 minutes or so tonight and then get together in the morning and try to at least wrap up everything other than RICO. Does that sound reasonable?
Yes, Your Honor.
Okay. And then obviously I'll get a final determination after the state rests of whether the defense wants to present a case and whether the defendants want to testify and what have you. But at some point fairly soon, if there isn't going to be a defense case, we'll need to tackle the RICO. And I think that the state wanted to bring Mr. Floyd in for that part of the argument. So I don't know exactly what the timing is going to be, but give him a heads up that, you know, maybe as early as tomorrow afternoon.
He's aware, Your Honor.
Okay.
Probably this week.
Okay. Oh, this is a bit of a gamble. Now, I do know Mr. Weinstein probably won't put up a case in chief. I assume that Mr. Shard would have at least a half dozen or dozen witnesses. Wow. No, Kurasan, you might have to order plane tickets to the US. There's not physically possible for me to get to the United, well, physically. But I'm keeping tabs of plane tickets and hotel stays. And also, I need a week off from work. That's the issue here. And in order for me to make this even close to sustainable, we're talking about between $6,000 and $8,000. I don't have that. So yeah, I wish I had it. But my planning for getting there for closing arguments was to be there in February or March, because I have my vacation days, I have saved up and everything. So damn. Yeah.
All right, so y'all have got a draft that we've all been working in, the state, the defense, and the court, exchanging emails back and forth, not emails, but exchanging the document back and forth with various edits to it for the offenses. So if we all want to pull that up. And I assume, just for record purposes, that each side has filed what.
I much appreciate my mods trying to elicit, give Nick enough money to get to Atlanta. But I mean, that's too much money in this amount of time. It's too much. I appreciate it, mods, but I mean, that is the cost is more than I made from this channel this entire year. So I can't, it's just not going to happen in this short amount of time. Yeah, but Christmas is coming up.
What they sent originally as their proposed. Okay, but you can. If y'all want to, I mean, it seems like we're gonna reach agreement as to the final form of most of this anyway.
Thank you, Young Commune. Says, I'm behind, but what I have seen, Love has not really been around since the plea deals. I think if she is not at least present for closing, she was told not to be there anymore. Yeah. I mean, since the plea deals, she's been in the courtroom maybe once or twice. But I assume she's been explicitly told, get out.
Way, but if, you know, I'll just say, if anybody wants your original version in a potential record, just file it. Okay.
Thank you, Your Honor.
Okay. And so as y'all all know, what Ms. Percival did was just take the state's charges, the defense charges, and consolidate them all into one document. And that's the document we're all looking at now. And anything that the court has asked y'all to think about, I have indicated that in some way in this document. And then y'all took a look at it and you have let me know the things that everybody might agree to. So let's just run through it. I think most of it won't take very long. So the very first one, and I just moved 1.20.30 up to the front because it seems to make more sense there than later. But I had suggested that we use the word admitted instead of presented when it says it's your responsibility to determine the facts of the case from all of the evidence either presented or admitted. And the defense is fine with that, and the state has questions.
Okay, so they are not addressing, apparently, Ms. Burrito's screw up or anything of the sort. So now we are in there discussing jury instructions and how to present the charges for the jury.
Is what y'all's note says.
Yeah, and folks, holidays are near. Don't, I mean, if you don't have the means, don't send super chats or PayPals or anything. I'm good. There are people who do have the means, who does support this channel monetarily. What you can do is watch my videos. That way, if you put, for instance, my Fulton County Fails playlist on repeat, that gives, that, I mean, the more views, the more the channel grows, the more people come to see it. And I get some ad revenue as well. For instance, I think I am at $3.30 per 1,000 views. So every time there's 1,000 views on my old videos, hey, I got $3.
So what is your question about that particular change? Or I can just explain why I think admitted is a better idea than presented. And that is because all kinds of evidence gets presented, but ultimately excluded. And I don't, obviously they can't consider anything that's been excluded, whereas they can consider everything that got admitted.
And I think my question, Your Honor, was regarding testimony. We normally say admitted as physical evidence, but if there's testimony, we normally don't say listen to the admitted testimony. And so I didn't know if there was confusion that what was testified to is something different than the evidence that was admitted versus like versus pictures or physical.
Yeah, so there's down below, there's going to be an explanation of what evidence is, and it's going to say it's both exhibits and testimony. So evidence encompasses both of those things. And I hear your question, but I'm going to go with admitted for the reasons I already explained. And then the indictment, it sounds like the state agrees that we'll just read out the charges that each of the defendants that are still with us is charged with. Is that right?
Yes.
Okay. My question is kind of, whether in reading the indictment, y'all want me to read every one of the 150 or 60 something overt acts, which I'm not particularly excited about, considering they're going to have a paper copy of it out with them. Thoughts on that?
Your Honor, our preference and our argument is that for count one, just the charges be read.
191 overt acts.
Yeah, I don't think we need to read the 190. I also don't think we need to read the preamble
I
to
don't
the
either.
191 over acts that the state wrote in the indictment. So I believe it would be, I mean, they've already heard Judge Glanville read it before in jury selection, and I think before we swore in the jury, and I think it would be prejudicial just to
Well,
continue.
I don't plan to do it because they're going to have it out with them anyway. They'll be instructed about how to consider them all. I don't need to read every one of the overt acts, so I don't plan to do that. Okay. All right. 1.1, I suspect that's 10.20. Everybody agrees that's fine. 1.2010, everybody is fine with, and I had just added its pattern, except that I had just added basically like, you know, generally speaking, these charges are going to say a defendant, but obviously you have to make a determination separately as to each defendant, and everybody seems fine with that. All right, so down towards the bottom of that particular instruction, and I'm on what's currently page 4 now, the highlighted part, it says, I had noted that this was not pattern, this particular language. And interestingly, it says acceptable to defense, but state has questions about the changes that I made. The state's the one that requested the original version of that. So I had stricken through after hearing and seeing the evidence and just changed that to after considering the evidence. I struck presented in this case because that's just surplusage. It's obviously the evidence in this case. And then I changed it is your duty to convict to you would be authorized to convict. What are the state's questions or concerns about those changes?
I would need to, I believe, when this was pulled, there was language that said it is your duty, and so I need to speak with the state representative who drafted this.
I know it said it is your duty. I struck through that because it's not what we say as judges ever when we're telling, every time we're talking about you can acquit or you can convict, we never as judges say it's your duty to convict. We always say it's your duty to acquit, you'd be authorized to convict. So that will be the way I'm saying that. And then, so was that your only issue with that one?
Yes, Your Honor.
Okay. All right, y'all are fine with grave suspicion. Y'all meaning both sides. Both sides are fine with the general charge on evidence. Y'all will put together what the stipulations are. And y'all need to do that fairly soon.
Yes, Your Honor.
And I think that all the stipulations have been stipulations of facts, not stipulations about testimony, documents, or exhibits, which is why I struck that last part, because I don't think it's applicable. If that changes once y'all look back, just let me know. Okay, moving down to 1.30.20. As y'all all know, there's a short version and a long version of the direct and circumstantial evidence explanations. And both parties had requested the long version, which is fine. The red additions, none of those are non-pattern. Those are all pattern language. They're just from the short version. So it's kind of intermixed in with the long version, but there's the one defendant, in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. And the note was defendant subject to this non-pattern language and that it's unnecessary. State finds the language acceptable. That actually is pattern language. So, I mean, y'all can still object, but given that it's pattern and been pattern for years and years, I'm going to go ahead and give that. Y'all okay with that?
My objection is, and I understand what the court is saying, my objection is that the instruction as a whole is essentially saying there's no difference between direct and circumstantial where it comes down to it. I didn't see the need, it seems, to put in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions.
All right. So one thing I wanted to know is when I normally give this charge in other cases, I have said that language at the very beginning. So you'll see where there's that green paragraph right below the heading. Evidence may be either direct or circumstantial or both. If you would rather I say it there, I didn't know if there was an objection to where it was placed.
I don't have a preference for it.
Okay. All right. Is there an objection to the language about there being no legal difference? Or are you okay with that part? In the weight you can give to either direct or circumstantial.
I'm trying to find that language. Oh, I see it now. I'm sorry.
Right now, I have it at the sort of towards the bottom, but I could also do the green paragraph instead.
I don't have any preference.
Problem with that? Okay. Okay. All right. So next was inferences from the evidence or lack thereof. This was requested. Okay, you're going to withdraw that one. All right. All right. Credibility of witnesses. Everybody's good with that. And while the intelligence possibility has been either inserted or reinserted into the pattern charge, I would be disinclined to give that unless the defense wants that.
Are you, Your Honor, are you telling us it's been reinserted into pattern, or are you?
Well, I don't know if it ever got removed, but it is. I looked, and it is still in the pattern.
I think it's disfavored.
It is definitely disfavored. So unless y'all want it, I would not want to give that
That's fine.
particular. Okay, so we will get rid of that particular quality, I guess, including that one. Okay. 13130, expert witnesses, seems fine with everybody.
Yes, Your Honor.
All right, on the 3140, state's going to make a list of prior convictions under 609 is what the note says.
No weapon for me dying against me. Asked if found not guilty, will these defendants go home? Unless they have other charges on which they're on jail for, yeah, then they go home. They are being taken back. If they are found not guilty and they have no other pending charges in other trials coming up, yeah, then they will get to the jail and they will get the booking out paperwork, and then they get to go home. Thank you for the super
Y'all
chat.
wanted me to read those? Because I wouldn't plan to read those.
Ow. Mr. Jingles, you can boot me without your claws.
Okay, so y'all don't have to make a list of them unless you want to. So,
I'm sorry, we're talking about listing the individual convictions?
yeah, which they have now said they wouldn't want either, and I wouldn't do regardless. Okay, so do we have, we charge only the ones that apply. Do we have evidence offered to attack any witness's credibility with a character for untruthfulness shown by bad acts, as in specific instances of conduct?
I don't know if it was introduced in that way. I can't remember if Your Honor was here. Mr. Copeland was on the stand, and there was discussion about an incident where he accused a jail worker of beating him and tasing him and macing him, I believe.
Okay.
And then he was charged with false report of a crime, and then it was dismissed by the state, how it all came out.
Yeah, I was
And
here
so,
for
so I do believe that would fall under 24-6-608A.
that. Okay, so I think we would say this may include evidence of character for untruthfulness shown by specific instances of conduct of the witness in question. Was it brought out on cross-examination? I would imagine brought out. Okay. So just not the shown by bad acts, just shown by specific instances of conduct. Okay. Do we have bias toward a party shown by specific instances of conduct? And that would be either for or against a party.
Also, folks, plea deals can be brought and accepted or denied all up until the jury hands the paper to the judge. We have reached a verdict. We have to remember that. So we don't know what's going on in the background. That if there are some kind of plea deal negotiations going on in the background, we don't know. But it is a possibility.
If y'all both, want it, whether we have it or not, I can charge it, but.
I don't think.
Recall that.
I wrestled with Mr. Copeland's testimony because there's a lot of things that came out regarding things that Mr. Copeland did that could show bias towards a party, bias in favor of defendants. If that would include him shooting.
Can you speak into the mic, please? I mean, I can hear you, but it's a lot easier when you're speaking into the mic.
If that would include him shooting at the studio.
Or grab a remote movable mic. Okay, so you think, yes, there are some of those?
Yes, Your Honor.
Okay. Any objection by the defense to given bias towards a party shown by specific instances of conduct of a witness that may relate to the witness's bias toward a party?
No, Your Honor.
Okay. And then obviously we have some criminal convictions. But we don't have, we have definitely felony. Do we have a crime of dishonesty or making a false statement for any of them?
I don't believe.
All right, y'all double check with me. We can just highlight that for now and y'all double check. I don't think we do, but okay. And then do we have character for untruthfulness shown by opinion or reputation? Other than Woody himself saying, I lied about everything. That's not an other witness though. That's himself.
No, I don't think so.
Okay. And then we've covered the specific instances up above, right?
Yes.
All right. So we can get rid of that part. Okay. All right. Next is 1.31.42 witness supported. The state requested this, defense objects. We've just determined that credibility has been attacked in some of those ways. So what part does the defense object to? Has there been evidence offered to support the credibility or believability of a witness whose credibility has been attacked? We don't have a specific, do we have specific instances of truthful conduct or lack of bias?
Antonio Sledge is what.
Okay. So I guess, yeah, Antonio Sledge certainly.
Hey, Goddess, member for a whole month. Thank you for your continuous support of this channel. Saying so glad to be a member. Nick is a great lawyer. Thank you. I'm a jurist, not a lawyer, but thank you so much. Thank you so much. It's basically the same thing, but I don't work actively as a lawyer, and the term lawyer is a protected term, a protected title over here. So jurist, yes. Lawyer, no, since I don't actively work as a lawyer. I am a senior negotiator. I'm contracted by a union, but I do not do actual lawyer work. I do have a law degree and everything that comes with it, but so that's the difference. I know it's splitting hair. If you want to call me a lawyer, sure, go right ahead. But just for reference, I'm a jurist, not a lawyer.
Would be included within the specific instances of conduct that may relate to his character for untruthfulness, I would think, if there was some evidence that he lied under oath. Right?
Well, that was the way I looked at it. That was impeaching him about the statements at hand. Not the way I view this as like you have a history of lying about prior things. Not we're calling you a liar today in court.
Okay, well, regardless, what is the defense objection to the 0.31.42?
Well, this is about, as I understand it, it's about rehabilitating someone whose credibility has been attacked. And I don't recall any positive character evidence of truthfulness provided by anyone. And I don't remember any testimony about the lack of, like, this is rehabilitation, and I don't recall any rehabilitation of any of these witnesses.
Yeah.
So has there been evidence of character for truthfulness? I don't think so. Or lack of bias?
Sorry, Your Honor. No, there has not been.
All right, so what I think I typically do is if those specifics don't apply, because the pattern says this would include and then gives the example of character for truthfulness or lack of bias, we can just give essentially the first sentence of that pattern without the example. So it would just say, in determining the credibility of any witness whose credibility has been attacked or challenged, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. Any objection to that?
No, Your Honor, nothing's good.
Defense?
No, Your Honor.
Okay. And then 13145, y'all are fine with. 3147, y'all are fine with. 3180, everybody's fine with. Okay. 3190 and 92, y'all are fine with.
What about
Yeah.
90X?
Well,
This is,
Well, sorry, I mean, it says state and defense agree no changes, which is why I said that.
That
If I'm
was on-
wrong, go ahead and
That was
let
on
me know.
92, Your Honor.
on 90, I objected, but if this is
Oh,
pattern,
I'm sorry, it doesn't have any indication that you objected.
I did, but maybe.
Okay, that's fine. I mean, yeah, if I skip something or if the notes are wrong that Mr. Weinstein did,
That would be my note taking, Your Honor.
then yeah, please let me know.
But and the reason I objected is I was under the impression that this was now disfavored. But if it's not disfavored now, then I was thinking about the Nagel case, and I think I was mixing up this versus the presumption of truthfulness.
You might be
instruction.
more up on it than me, so
Okay,
if you,
let me-
if you
yeah.
want to take a look back at it, and if it's disfavored, then certainly we
Okay.
would think about, but.
I'm not saying it is, but I'll
okay,
look at it.
All right, so double check on that.
Hey, Catnut Williams. Hey.
All right. Any preference on 9.2, whether I say testimony of an accomplice on its own or a testimony of accomplice by itself? Anybody care?
Have you already ended?
Nobody cares? Okay. All right, I'll pick one.
Oh,
Okay,
you are.
9.3. Y'all agree?
hey. And she gifted 10 memberships. Thank you. Hey. Brings us to 60 new members today. 60. 9 away from the magic number. Oh, thank you so much. Yeah. Oh, what a first o'clock today. Cat, not William. Cat. What a first o'clock. They had Mr. Weinstein, when he showed the picture of Ms Burrito with the actual clock watch in her possession. Oh, that was so much fun. That was so much fun. And she actually, Ms Burrito follows the case on Twitter because people are mentioning her. It shows up. Yeah. You might. That is technically violating a court order, in my opinion. She is not to consume anything about this trial. If she finds out that she is mentioned on Twitter, go off Twitter. But no, she didn't. She followed it. She studied it to make up a bad answer.
Oh, I'm sorry, 9.3A, y'all agree. 9.3B, y'all are saying this might need to come in because of the statement by Stillwell when he was a victim. Is that right? Or that it was his Audi? That's fine. I wasn't thinking about anything like that, but that's fine. We can get that. And then assuming that neither defendant decides to testify, we'll give 3210. All right, 3216, it looks like everybody agrees. We don't need that one. Or all the way, or 1718, 50.
And I will say, just for the record,
Yeah.
that I am cognizant of the fact that Mr. Stillwell did give a statement. I think it was not ruled to be custodial by the prior judge. Arguably, it is, I think, in the back of a car when he was a victim. That being said, I'm not going to be arguing at all that it's not voluntary or even go down that road about proof of voluntariness or conditions precedent. So I just want the record to reflect that I'm knowledgeable about that statement, but I don't believe that these apply, and I wouldn't be making any arguments
All
to
right,
this effect.
thank you.
Yeah, and I'm not objecting it to being removed because
All right.
Mr. Kendrick's statement did not come in.
Okay, and then 1.3400, everybody's fine with that as it reads right now. 1.3420, prior difficulties. I had asked, do we have this? And it says defense does not believe this needs to come in. State believes Copeland's prior statements might necessitate this instruction.
Yes, Ron, so
Oh, they're talking about Woody.
Copeland's statement to the police, specifically his June statement, he discusses that at the time when he does the statement around June of 2015, that he thought that Mr. Williams was trying to, even though Mr. Williams is not here anymore, but he did discuss that Mr. Williams, he thought was trying to kill him at the time, trying to harm him. And so we were thinking about that as far as prior difficulties. And that's what I was thinking of
Okay.
at the time.
All right, so this charge would talk about evidence of prior difficulties or lack thereof between a defendant and somebody else. And our only two defendants are Mr. Kendrick and Mr. Stillwell. So given that, what are your thoughts?
in that statement, there are
Portions where he talks about where Mr. Copeland does discuss in that same statement his challenges with Mr. Stillwell at the time. And when I say at the time, I mean in 2015. It's not as profound as when he talks about Mr. Williams, Your Honor, but there is some evidence, at least through that statement, that at the time, back in 2015, specifically June of 2015, that his relationship with Mr. Stillwell was not the same as it had been previously.
All right, and if that were the case, then it would read evidence of prior difficulties between a defendant, I guess, and a witness have been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the witness. Whether this evidence illustrates such matters is solely a matter for you, the jury, to determine, but you're not to consider such evidence for any other purpose.
I still don't believe that we need that, Your Honor, especially because Mr. Kendrick is not involved in that alleged dispute.
I just think it makes it really confusing
Yeah.
because we don't really have prior difficulties anyway. We have at most Mr. Copeland saying, some version of I'm worried Mr. Stillwell doesn't like me or has it out for me or whatever, right? We don't have actual prior difficulties.
correct. We don't have any.
Like they didn't get in a fight or have a war over Instagram or anything like that.
No, we don't. have
Okay.
that, Your Honor.
All right. I think it would be cleaner then to not include this.
Good choice.
All right. 3430. Everybody agrees with that as written. Is that correct?
Yes, Your Honor.
All right. Identification. Everybody agrees to 1.3510 and 11. As, yes, no?
Yeah, I'm sorry. Yes, I was thinking whether we even had 13510, but I believe we did with some of the overt acts.
Well, we do for,
Oh, look at that. Thank you to Derek for setting up a monthly payment via PayPal of $2. So thank you, Derek, for setting that up. Yes, that is something you can do on PayPal. Set up a monthly, and I very much appreciate that. Thank you so much to Derek. I don't know who you are in the chat. Wave if you if you're here. But thank you so much. That is so very nice of you. Thank you.
which is like the Ryan murder that he's been convicted of. And
There was an incident at a gas station on Jonesboro Road, I think it was.
Okay.
Or Lakewood, that also had identifications.
Okay, so on 1-1 though, we were talking about, normally that's talking about identifying a defendant as a perpetrator, which is not, we're talking about, do we have a defendant being identified as a perpetrator of any crimes either of them has been charged with, or are we just talking about overt acts?
I think we're just talking about overt acts.
I mean, there's no witness that identifies Mr. Kendrick as a perpetrator
To any of the crimes with
Correct.
which he's been
for
charged,
any of the
right?
counts, correct?
Okay. And I think the same for Mr. Stillwell?
I can't swear like if
I mean,
in
it's,
the, in the interrogations of, or the interviews of Mr. Copeland or Mr. Zachary, I think they may have had like single photos and like said, do you know who this person is, that sort of thing, but I don't really take that as an identification.
yeah.
How about
Right.
that?
What I'm trying to parse for myself is on 1-1, do we just say sufficiently identify the defendant beyond a reasonable doubt as the perpetrator of any of the crimes with which he is charged, which is like actually language that I added instead of, it normally reads beyond a reasonable doubt as the perpetrator. But if we're also need for them to consider, did some alleged co-conspirator commit some other overt act? And we do have eyewitness identification of potential co-conspirators committing overt acts, then
Potential co-conspirators, unindicted co-conspirators, and unknown unindicted co-conspirators are in this damn trial. Because Georgia RICO allows it.
I think probably that's a stay.
it's not really identifying the defendant then. It's
No, language.
identifying like any alleged co-conspirator.
The language would need to change in that case.
I could say sufficiently identify any conspirator. I don't even know. Y'all think about that with me. Because or we could say the defendant and then like also do another explanation for overt acts. Or not say anything at all. We need to come back to this one. Ms. Pershfield, just highlight that whole thing and maybe give us a note as to why we're coming back to it. All right, everybody agrees the fingerprint one is unnecessary. And on the DNA, we left that with y'all's notes say that the state and the defense agree that this is probably unnecessary, but the state is double checking. What'd y'all come up with?
We had not have actually double checked.
Okay, well, double check, but I don't think there's any DNA evidence.
The only one I could think of was there was a 2013 alleged armed robbery where there was some blood in the car. But I don't know.
Did y'all have a DNA expert come say that blood belongs to anybody?
No.
Okay, well then we don't have DNA evidence. Although I'll leave it in until the state double checks. All right, 1.40.10, y'all are fine with it being said a crime occurs when the law is violated by a defendant's intentional action?
Yes.
Okay. Intent, everybody's fine with, no presumption, everybody's fine with. Presumptions and inferences, 1.41.12. Defense says it's inapplicable. It's not inapplicable. I mean, it's
Well-
always true.
It is always true. I don't think it's necessarily tailored to this case. I don't believe that that is going to be an issue at all about mental states, or there's going to be no mental defense.
Okay, I see what you mean by that. Thoughts on this? I mean, I typically give it, and typically mental health defenses aren't an issue, but state,
We don't think we need, however, we don't know what arguments may prevail.
all right, I'll just leave it in. Okay. 1.42.10, parties to a crime, requested by the state and the defense. It says the defense does not object if this is tailored to the Donovan Thomas murder only. That would be interesting.
Yes, Your Honor. I don't believe that, obviously in some jury instructions, they apply to all acts. But sometimes they apply to certain acts and not others. Mr. Stillwell has been accused of being the shooter of Chamel drinks. There's been no testimony any other way other than him being the shooter, as being the principal, not as an accomplice, not as party to a crime. There's been no evidence that Mr. Stillwell is a party to a crime of the Chamel drinks case. So I would object, and I understand that the state wants it, especially with Mr. Kendrick. I'm not sure. It's unclear to me what role they think Mr. Kendrick played in the Donovan Thomas at this point, but I would assume that would be as a party to a crime. So I understand the state's request for that act. I don't think it applies to Chamel drinks.
So I think the state's evidence has Mr. Stillwell driving the Audi, and who's in the front seat with him?
Demikian Garlington.
Okay. And then their theory is that the fatal shot came from the Audi from inside, that they didn't stick a gun out. I don't know if they've gotten to the nitty gritty of it was Mr. Stillwell and not the passenger.
Well, they've thrown out hypotheticals of Mr. Stillwell opening the door, of Mr. Stillwell sticking his arm out the window. They also had Detective Hogan. I had him very clearly go through his warrant and his theory that Mr. Stillwell was the shooter, and we haven't heard any other evidence.
I mean, the detective's theory and what the state ultimately wants to present aren't, they're not bound to the detective's theory.
Absolutely, but now we're on the last witness.
Yeah.
And I still haven't heard anything contrary to the argument that Mr. Stillwell is the shooter from the passenger seats. I mean, from the driver's seat. So I just don't.
Well, let me
feel it's
pause and
appropriate.
ask the state if is y'all's theory 100% Mr. Stillwell was the shooter, or?
That is what they have gone for so far. Mr. Stillwell from the gas station pulled up on the intersection, pulled up, fired, drove off. That's been their theory. Let's see if they stuck to it.
What's your take on this?
We can never be 100% because we were not in the car. However, Your Honor, we believe that Mr. Stillwell was the driver, but the jury can infer from the evidence that Mr. Demikian Garlington leaned over and shot the weapon. We believe that Mr. Stillwell shot the weapon out of the driver's side vehicle.
They want to have both sides of the apple. They are intentionally vague in order to present to the jury, it doesn't matter if he fired or not. That is, sadly, they are allowed to. Vagueness is allowed in Georgia court.
Your Honor, but with any of our pattern charges, nothing is tailored in an indictment to a specific charge. It's just read, and we argue based upon what the charges are. So we would ask that 1.42.1 to not be specified for any charge, but that it is a jury charge that is just read to the jury, not specified to a specific count in the indictment.
I mean, I've never given parties to a crime and said this only applies to, which doesn't mean it can't be given that way, but I've never even been presented with that argument. And frankly, well, okay, I mean, I hear and understand the objection, but I'm not gonna limit it.
And Your Honor, this is my fault. I just wasn't anticipating that we would be reviewing this today. If I can find some case law that.
Yeah, that's fine. And frankly, it's 5 till 6 and we haven't gotten through, and I know we don't want to be here until 7. So let's just pause right here for the evening, and let's, can everybody be back at 8:45 in the morning, and we can get through with, I think, this part of the charge conference?
Yes, Your Honor.
Okay. And I've been working on a RICO charge, but I'm still working on it. Does anybody have anything more to present than they've already presented on the RICO in terms of potential language? I know your argument, but
Yeah, at this point, I don't have any additional language.
All
to-
right, well, I will share. So as the pattern jury instructions have been updated in plain language, and not all of them have yet, but like, for instance, murder has. And so now it reads, the state must prove 1, 2, 3, or whatever. And it's been done for a lot of those. There's been a move towards that. There is no pattern for RICO, but what I am trying to do is put the RICO charge in that same kind of format. The state must prove A, B, C, D, E, F elements. So if it's in enough of a form for me to share that, I can, through Ms. Persfield, share that with everybody to take a look at tonight. It is nascent still. It is not fully formed, but that way y'all can at least have some thoughts as to what I'm thinking would be a correct and also helpful charge for the jury. Okay.
Thank you.
All right. See y'all at 8:45.
All right. That is the end of day 162. As you might have noticed, I did not cover the direct examination because I frankly don't care about her what she did wrong there will be brought out in cross-examination, and that will continue tomorrow at 10:30 a.m. Eastern Standard Time, which means I can live stream it. Yay! Yeah, so tomorrow I will start at around 10, just to be sure. Oh, no, they said 10. Okay, so I will start just before 10, which is just before 4 p.m. my time. And then we will go until they're done. And I do believe Max has indicated he needs a full day of cross-examination. Not sure if he will. It depends on how much she screws up tomorrow. So, all right. Let's go through some here. Dave saying Logan says hi. Hi, Logan. Sebastian Miller gifted 50 memberships. That is so amazing. And he is declared honorary Viking of today. Sebastian Miller. Thank you so much. Dave again says, Olivia also says hi. Yeah, Logan and Olivia are his kids. Thank you so much, Dave. Jessica, the level of incompetence with the law enforcement in this trial is staggering. Yeah. How do these people go to work each day knowing that they are this crap? How, and they get convictions. That is why. They do just enough police work to hand it over to the DA's office, who will spin it to something that a jury might believe. And they get convictions. It's lazy because sadly, jurors are lazy in many cases. Young Commune, damn it, Doug, I'm a gang expert, not a juror. Oh, Young Commune, I'm behind, but what I have seen, Love has not really been around since the plea deals. No, she hasn't. Maybe once or twice she's shown her ass in court. And seems like District Attorney Fannie Willis saw where it was headed and yeeted her out of there. No weapon for me against me. If found not guilty, will these defendants go home? Unless they have other pending charges, yes, they will go home. Goddess, so glad to be a member. Nick's a great lawyer. Yeah, we went through this. I'm a jurist, not a lawyer, because in Sweden, lawyer is a protected term, and I do not work as a lawyer. I'm a senior negotiator, a jurist, so to speak. But thank you so much for being a member, Goddess. And then Cat Note Williams, in the end, gifted 10 memberships. I saw this. Yeah, if you want one trial to get absolutely furious about, besides this one, check my Zachariah Anderson trial coverage. It's one of the first cases I covered on this channel, so you get to see a younger me. But yeah, that trial needs more attention. He is currently preparing his appeal, and I have done fundraisers for his appeal, and hopefully it will be successful, because that conviction was absolutely horrifyingly bad. We have to do something special for Kat. She's so awesome. Yeah, yes, something. Absolutely something. I don't know yet. Should we have a Cat Not William appreciation stream after this trial is done? Where I cut out fund. Yeah, maybe. Or if you guys can help out. So, okay. All right, folks. It is 1:30 a.m., which is earlier than I usually. And these streams, I actually have time to have proper sleep before I have to go to work. But all right, folks. Thank you guys for being here. Thank you for allowing me to do this. Thank you for the monetary support. Thank you for the thumbs up, the subscriptions. You are the reason this channel keeps going. You really are. And yeah, remember, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. I'll see you here tomorrow, 9:45 a.m. or something of the sort. Okay? Bye.